start with some basics about trusts. And a trust is an entity or a person, if you will, that lawyers typically create. But they're different than other entities that we see, like corporations and LLCs and partnerships and companies, because a trust doesn't have an owner. It's a pure person, and it's treated as such legally. Trusts can own all kinds of properties, real estate, co-ops, securities, cash, stamp collections, you name it, a trust can own it. When we're creating a trust, it always starts with a trust agreement. And the agreement is between the person who is desiring, creating, and funding the trust. That person is typically called the grantor of the trust. And the person who is going to manage the trust. That person is called the trustee. Sometimes in certain kinds of trusts, the grantor and the trustee can be the same person. But we'll talk about that a little bit later in the presentation. And as I already said, the trust can own any kind of asset. The trust typically is going to have a beneficiary or beneficiaries. These will be the persons who are entitled to receive trust assets, principal amounts, or income during the grantor's lifetime or after their death. And they're all different kinds of trusts that lawyers can create. And we think about the type of trust to use depending on what objectives and what goals our client has. And that will dictate the type of trust that we would want to create. For disabled persons, that type of trust would typically be a supplemental needs trust. And we'll talk about that a little bit later on as well. So these are the kinds of trusts we'll be talking about today. Revocable trusts that are sometimes called living trusts. Irrevocable trusts as in not revocable, and supplemental needs trusts that I already mentioned. And we'll also want to distinguish between trusts that are inter vivos trusts or testamentary trusts. So an inter vivos trust is one that the grantor is creating during his or her lifetime, whereas the testamentary trust is one that comes into being upon the death of the grantor. So a testamentary trust would typically be one that is included in that person's will or in another trust. So what we have here in most cases is estate planning, where our goals are to transfer the money and property that we own upon our death to the people who we want to receive our estate. And we want to do that hopefully in an efficient way and in a tax effective way. Although I think for most people, I get a lot of questions about estate tax, but for most people, there's really no concern about estate tax. For federal purposes, each of us has an exemption of $13,990,000. You can double that amount for married couples, so almost $28 million in tax exemptions. And on the New York State side, The current exemption amount is $7,160,000 per person. So I think you can see most people are not worried about it. Actually, only about 0.1% of estates pay federal estate tax. But the other point here that's, I think, really important for many people is that having a will or a trust doesn't guarantee that you'll have an estate. You also need to have a plan or incorporate a plan that is protecting your assets during your lifetime. And probably the risk that you need to protect against yourself that you may not have thought about is the expense of long-term care and health care. And I'll talk a little bit about that later on also. So, but just to start with, when we think about long-term care meaning an aid in the home, assisted living, nursing home, adult daycare, this kind of thing. Your medical insurance, your Medicare, whatever it is, that does not cover long-term care. So unless you have long-term care insurance, you have no protection against it, and it's very expensive. So I think it has a place in every discussion about estate planning and about trusts, unless you're just very, very wealthy and it doesn't matter. All right. So to begin with, let's just make a distinction between trusts and wills. Both are used in estate planning. With your last will and testament, only the assets that are in your individual name when you die are subject to the terms of your will. And for most people, there will be some assets that will not be in your individual name when you die and will not be subject to your will, even if your will says something about them. An example might be a retirement account like an IRA or a 401k. If you've named a beneficiary directly on the account, that account will belong to that person, regardless of what you say or don't say in your will. If you own property jointly with a spouse or a sibling or a friend, it may be that the survivor is the one under the deed who is going to get that property. Again, it won't matter what you say in the will if you say anything about it. So, very important, again, the will only covers the assets that are in your individual name when you die. And also, it cannot be enforced without a probate proceeding in New York in the surrogate's court. So a will necessarily involves a court proceeding. Cannot be forced without it. And obviously, it's not going to protect your assets or facilitate Medicaid eligibility or other government programs. Now, the trust also controls and speaks to only those assets that it owns. So remember, a trust for legal purposes is another person. So if you want a trust to control your assets better have been transferred into the trust. It's not enough to say in your trust, I want to leave my house to my children. That'll work if there's a deed that transferred ownership of the house to your trust. But if there is no deed, then the trust, no matter what it says, is not going to control that asset. Unlike your will, trusts are private and they are managed and can be managed by a trustee without involvement of a court. And a lot of people do estate planning trusts specifically for that reason. They don't want to leave their spouse or their children with the obligation and inconvenience and expense of going through that probate process in the court. Then certain kinds of trusts, and particularly our irrevocable trust, that is the type of trust that will protect your assets and facilitate eligibility for Medicaid and other programs. So I think this is something I wanted to also bring to your attention. Can we or must we leave assets to anybody in our family, in our circle? Yes, a spouse. All right, you cannot disinherit a spouse. A spouse is entitled to, as you see in this slide, the greater of $50,000 or 1/3 of the net estate. And 1/3 of the estate includes all the assets, whether they're covered by the will or not covered by the will. They're in a trust or not in a trust. They're in an account with a beneficiary or not, doesn't matter. It's 1/3 of everything. And then the other thing on this slide that you may find interesting is nobody else has any rights here to a share under a will or a trust. Children may think they're entitled or expect that they are, but if they're not named in a will or a trust, they have no rights. It's only a spouse who has a right to a share of the estate. Now, that doesn't mean that a child can't contest a will, because yes, they can contest it. And if they succeed in having the court declare that the will is invalid because mom or dad lacked testamentary capacity, or the will was procured by undue influence or fraud or some other reason, and the will is set aside, then a child or whoever it is who's contesting may have rights under New York law as an heir at law. But otherwise, no, you don't have a right to a share under a valid will or a trust. So let's take a closer look at our revocable or living trust. This is really purely an estate planning trust. Its goal is to keep the estate out of court. So if that's what you're after, the revocable trust is your answer. And it's very appealing to clients because most people want to stay in control of their money and property. And with a revocable trust, you can be both the grantor and the trustee. So you're the person who is creating and funding the trust, and you are the person who is in control of the trust. And as the grantor, you can revoke the trust at some point if you decide you want to do that. Take everything back. You can amend the terms of the trust. You can change anything. You can put money and property in. You can take money and property out. It really is just an extension of you. It only becomes fixed upon your death. So when you pass away, you have named a successor trustee who takes over, and that person's job is simply to distribute the assets in the trust according to the terms of the trust agreement that you entered into with yourself. So again, this trust is very useful for those who wish to avoid probate and keep everything out of court, keep it private, make it easy for your spouse, your children, your family members after your death. That's the reason for this trust, and it's very effective for that purpose. It does not, however, do anything to protect the assets that it owns. It does not provide any help at all in establishing eligibility for government programs like Medicaid or food stamps or anything else that is a means-tested program. So now our irrevocable trust, irrevocable again as in not revocable. Once you've set up this trust and transferred ownership of money and property to this trust, you cannot take it back. It's another person. It's as if you transferred your house or your bank accounts or your investments to your son or your daughter. It now belongs to them. You can ask them to give it back to you, but if they say no, there's nothing you can really do about it. An irrevocable trust is kind of like that. It's legally another person. So if you transfer your assets to an irrevocable trust, those assets belong to the trust, not to you, and you no longer have any control here. The control passes to your trustee. And if you followed my discussion so far about the irrevocable trust, that explains why it protects your assets. It protects your assets because those assets that are now in the trust don't belong to you. So if you have a creditor who's seeking to collect from you, that creditor cannot collect anything from the trust because the trust is a different person. And the assets in the trust are no longer your assets. And for the same reason, the irrevocable trust is going to help you with eligibility for programs like Medicaid, because in applying for Medicaid, Medicaid's going to ask you, what are your assets? Well, anything that's in the trust is not on your list because the assets in the trust do not belong to you. So hopefully you can see here that the trust is, this type of trust is very useful in providing asset protection and very useful in facilitating access to government benefit programs like Medicaid and others. At the same time, it avoids probate, as does the revocable trust. There's no reason for anybody to have to go to court here. When the grantor of this trust dies, the job of the trustee, the successor trustee, trustee or successor, is simply to distribute the assets according to the instructions in the trust agreement. Also, I guess I should mention that there are nice tax benefits for beneficiaries who inherit money or property from the trust. Actually, this is true of the revocable trust as well. When you inherit property, you get the property at its current market value. So imagine a situation where mom and dad have created a trust They prepare a deed and transfer ownership of their house to the trust, and you inherit that house. Well, if mom and dad bought that house 40 years ago and they paid $25,000 for it, and it's now worth $800,000 or some big number like that, we have a lot of unrealized capital gain. And if the house were sold during their lifetime, there would be a hefty tax to pay. But when you inherit that house, you receive it with an $800,000 value, or what tax lawyers call tax basis. So if you sell the house for $800,000 and your tax basis was $800,000, there is no capital gain, and therefore no capital gain tax. This is called a step up in basis. So very nice to inherit property, whether it's real estate, co-ops, securities, you name it. If you inherited it, you got it at date of death value. And in many cases, that's saving you a lot of capital gains tax. Is there a question, Cindy?
Yes, couple of questions. So question is, can an actively operating business be put into a trust? Like, for example, a real estate business?
Yes.
Okay, that's good. Then sort of does a living trust, does a revocable trust protect from lawsuits, creditors, or bankruptcy?
No.
Okay, simple, complete. All right, and the next, if a senior gets a discount for property taxes on their primary residence and then transfers the primary residence into a trust, does the person lose the property tax discount?
That's a consideration in drafting the trust, and if the trust is properly drafted, senior discounts should be preserved. Typically when we have a situation like that, we are going to put provisions in the trust that will allow the grantor both to live in that house or that apartment for the rest of their life, and to benefit from any senior discount that they previously or otherwise would be entitled to have. So no problem there. If you, going back to the first question, if you're going to put a business into a trust, then, if it's a corporation, the shares of the corporation would need to be reissued in the name of the trust. If it's an LLC, same thing. You would need to consult the LLC operating agreement to see whether and how that could be done. But yes, trusts can own operating businesses and frequently do. No problem there. On the second question, again, quick comment. Your revocable trust is essentially you for the rest of your life. Its purpose, again, is to avoid probate. It only becomes fixed upon your death. During your lifetime, you're in control of it. All of the assets are available to you. It's under your Social Security number. If it's available to you, it's available to creditors.
Okay, great. All right, thank you. Keep going.
Okay, we'll keep going then. So just a quick resume of the benefits of your irrevocable trust. The assets that you transfer to the trust are protected during your lifetime. As far as long-term care is concerned, you can have long-term care insurance, you can have Medicaid, you can have both. But certainly we would, at least in our firm, we're going to talk to you about dealing with that risk of needing long-term care. No probate, no court involvement. Your wishes, as you have expressed in your trust agreement, can be carried out privately without delay or any undue expense. Nobody needs to go to court. Nobody's going to fight about it. It is what it is. And as I was discussing a moment ago, your beneficiaries will avoid capital gains tax on the unrealized capital gains that accrued during your lifetime. So it's a pretty nice picture. There really are no, there's no bad news. There's really no negatives about doing this kind of trust, other than the work that needs to be set to set it up in the first place. But once you have it, there are really no negatives here.
Okay, another question. Sorry, before you go on.
Okay.
Is it possible to have two people be the grantors in a revocable, I guess, or in an irrevocable trust?
Yes, and very often it's a married couple who are both grantors. So yes, and you can also have multiple trustees of these trusts, revocable or irrevocable. You can have multiple trustees. So no problem there.
Okay, good. That's it. Oh no. Oh, before you go on, isn't it a disadvantage of an irrevocable trust in that the person loses control over his or her assets? They are placing their trust in someone.
Yes, you need to select a trustee, and your trustee should be someone who can be trusted, who has good judgment, who hopefully has your best interest in mind. So yes, you do have to put your faith into a trustee who is going to manage that trust for you. So if you see that as a negative or disadvantage, I'm afraid that that's what comes with your irrevocable trust. You cannot be the trustee of this type of trust. And here's the point. It's the fact that you do not have control of the assets in the trust. That's what gives you the asset protection. And that's what gives you the ability to obtain Medicaid benefits or food stamps or whatever it is that you're applying for, because it's the very fact that you do not control these assets and they're not available to you. That's what creates the benefits of this type of trust. So if you cannot bear the thought of giving up control, then then this type of trust will not work for you. But then you would have to forego the benefits that the trust provides, which is the asset protection and the access to government programs. So, all I can say is that yes, it's a concern for some clients. I think looking at it over a fairly long period of time that we've been in this practice, I would say that group of clients is probably a pretty small one. Most people come to terms with the idea that they need to have an independent trustee. Very often it's children, sibling, possibly a best friend. And even in cases where somebody doesn't have anybody who they're comfortable with in that role, we I think other law firms as well can introduce you to professionals, financial type professionals who are willing to assume that role, to be a trustee. So the problem can be solved if the motivation is there to solve it, I think. And I think it really comes down to, in many cases, the need for the benefits that become available, particularly if we're concerned about long-term care, because long-term care is just so expensive that it can, literally destroy your estate plan and wipe out all your assets. And we've seen that happen in many cases, unfortunately. Okay, anything else, Cindy?
Yep, sorry. They keep popping in one by one, but they're very good questions. So thank you everybody for asking. Can an active business be put into an irrevocable trust? And if so, can the owner of the business continue running this business?
Well, I guess if the question is asking whether the owner of the business is the same person as the grantor of the trust, I don't know. I'd have to take a closer look at how this would all operate, but to the extent that assets are available to a grantor of an irrevocable trust, it would compromise the trust for purposes of asset protection and availability of government benefits like Medicaid. So if it could be managed in a way where assets were not available to the grantor, maybe. It's not, I think, not typically what we would want to do.
Okay. And the last question is, which you already partly answered, if there are no children or friends to be trustee, what options are there? So that has become more of an issue because there are so many more people who are what are called now solo agers.
Yeah, well, in that case, we would typically introduce them to sometimes geriatric care managers, sometimes daily money managers, sometimes other financial advisors, professionals, sometimes CPAs. There are other professionals who are willing to accept the engagement of becoming a trustee. And
yeah, and you might want to mention that sometimes attorneys do it, but we do not.
Sometimes attorneys will do it. I think it's technically not prohibited by our rules of professional responsibility. It's not something that we do in our firm. I feel it's important for us to be kind of neutral and objective advisors rather than somebody who's handling your money and property and getting compensated for that. I'd rather keep it separate. I mean, that's the way we see it in our firm. There may be situations where attorneys are willing to do it.
Okay, great. That's all for now. Thanks.
Okay. So I think I mentioned this before, the testamentary trust versus the inter vivos trust, but the testamentary trust is one that we use pretty often, I would say. It's a trust that becomes effective and is funded upon the death of the person who's creating it. And the testamentary trust can be included in a will. or in another trust. So let's take a couple of examples. Let's say I have a son or a daughter who's, I don't know, 20 years old. They're legally adults. Under my trust or my will, they stand to inherit a considerable sum of money. I feel that even though I love my children, I am a little concerned that if at a young age, their early 20s, they were to inherit a very large sum of money, they might not handle it very well. It might get foolishly spent or wasted. So maybe I'm going to put in my will or my trust that if my son or daughter is under the age of, and I can pick whatever age I want. So let's say if they're under the age of 30, their bequest does not go to them directly, but it goes into a further trust that is held for their benefit. And while they're under the age of 30, money in the trust can be used to pay for education, pay for healthcare needs, for support, for other things that in the discretion of the trustee seem appropriate. And it's only when they attain the age of 30 that they actually receive the lump sum or whatever is there. So I've kind of deferred their bequest until I feel they're old enough to mature enough to handle it properly. And you can do what you want there. We even had one client who had two sons who provided that his sons would inherit, and they inherited a lot of money, but they did not receive it until they were 50 years old, 50. And I remember saying to this client, well, what's that about? What, you're really going to make them wait till they're 50? And he said, yes, I want to do that because both of them are very smart boys, and I think they're going to have good careers. And I wouldn't want the receipt of, a big bequest from me to be a disincentive to them in being successful in their own right. So when they're 50, they will have succeeded in their businesses or professions, and then they can get a nice inheritance from their dad. And they'll be satisfied knowing that they've made their own success for themselves. So that was one man's approach. Just maybe an extreme example, but many of our clients want to defer the bequest until a child is 25 or 30 or 35, somewhere in that area. Sometimes it's divided into a couple of parts. You'll get half of it when you're 25 and half of it when you're 30. So that would all be a testamentary trust. Another example would be a disabled child. We don't want to leave a sum of money to a disabled person who's probably receiving government benefits when the receipt of that bequest might lead to the denial of their benefits. So better to put that in a trust for their benefit that will not compromise what they're receiving from government programs. So those are some examples of testamentary trusts, and they are used extensively in estate planning practice and elder law practice. So the supplemental needs trust, sometimes called a special needs trust. This is where we're leaving money to somebody who is disabled. And we want to do something to help supplement and give them a better life. But we do not want to compromise their government benefits. And this is really important to know how to properly handle money that is going to someone who is disabled. Because sometimes, and frankly, we see this all too often, a disabled person who is receiving government benefits receives a gift or bequest from a relative or friend who's very well intentioned and well meaning, but the receipt of that gift has the opposite effect of what was intended. It just causes problems because now the disabled person is losing their government benefits. So there are different kinds of supplemental needs trust that are on this slide here. The first party supplemental needs trust, the pooled trust, and the third party. So we'll take a look at those. So the first party trust is one where the disabled person is probably establishing this trust for himself or herself. Could also be created by a parent or grandparent or guardian or a court. So here's the reason for this trust. The disabled person is in receipt of money. Well, how did that happen? Well, maybe that disabled person was the victim of a medical malpractice or an accident of some kind that caused the disability, which then led to a lawsuit that 2 or 3 years later went to judgment or was settled. And now, all of a sudden, this disabled person comes into a large sum of money. But meanwhile, that same disabled person had qualified for Medicaid and qualified for food stamps and qualified for other benefits because he or she couldn't work because they're disabled. And it would be best if they didn't lose those benefits. All right. And the way that can be avoided is to create a first party supplemental needs trust. So yes, the disabled person has received a sum of money. Now he or she is going to put it back into a first party trust that will permit them to use that money to make their life better and at the same time preserve their government benefits. So for this type of trust, we have to be under the age of 65. And we also have to be aware of the fact that if the person is on Medicaid, Medicaid will have the first claim against any remaining assets after the person dies. Now, if there are no remaining assets, then Medicaid can't collect anything. If there's a lot remaining after the Medicaid claim is satisfied, there could be other contingent beneficiaries. So, it just depends on the situation. So these are the circumstances where it arises. We've got a settlement or a judgment in a lawsuit. Typically the lawsuit that arose from an accident that caused the disability. Or somebody well-intentioned left a gift or inheritance that caused a problem with the government benefits. So Another option would be to use what's called a pool trust. And if any of you are familiar with Medicaid, you may know about the pooled income trust. Well, the same nonprofit organizations offer a pooled asset trust. It's really the same thing as a first party trust, a first party SNT. The trustee of the pool trust is a nonprofit organization. They manage it. If anything is left after death, it stays with the pool trust. I think in most cases, people would prefer to have set up their own first party trust and have a close friend or family member manage it, someone who knows them personally and is going to be interested in using the money in the trust in the best way to make their life better and more comfortable. But you know, this is a very good option for people who don't have someone that they would want to name as their trustee. And it's available to people at any age. You don't have to be under 65. Okay, also a little bit easier and less expensive to set up than the first party trust.
So David, there's one question about you know what? It's a question about a testamentary trust. Let's finish through the special needs trusts. I think that's better, and I'll ask you afterwards.
Okay. So the other type of supplemental needs trust is a third party trust. So that means that somebody other than the disabled person himself or herself who is creating and funding the trust. You know, probably my wealthy uncle or some other family member or close friend wants to do something to benefit me when I'm disabled. The smart thing to do would be to set up a third-party supplemental needs trust. And this can be done in an inter vivos trust, in other words, during the lifetime of the grantor, or it can be set up as a testamentary trust. So the uncle or the friend or whoever it is can decide to leave some money for his disabled nephew. He should put it, make that bequest in the form of a supplemental needs trust. So you'll see on this slide that you cannot set up a supplemental needs trust for someone to whom you owe a duty of support. So you cannot set up a supplemental needs trust for your spouse, who you are obligated by law to support, or a minor child who you are also obligated by law to support. You can do this as a testamentary trust, but you cannot during your own lifetime. And with the supplement of the third-party trust, there's no payback provision to Medicaid. So this is also a really important one. You know, it's kind of a shame when, you know, we see a family member who wanted to do something for a disabled relative and they leave a nice bequest, and it turns out that that bequest causes a problem because the disabled person who receives that bequest loses their government benefits. So if the donor here had been properly advised, they would have been told, look, don't make that bequest an outright bequest. Let's put it in the supplemental needs trust for the benefit of your nephew or your friend or whoever you're doing this for. So here are just some thoughts about what we put into a supplemental needs trust. It's to supplement, not to supplant the benefits from government programs. But look, money in a supplemental needs trust can be used for anything that makes the disabled person's life better, more comfortable, whatever you want to do, whether it's education or entertainment or care, whatever it might be that is helpful. The beneficiary has no control, can't revoke it or amend it. It's the trustee's decision, as it is in most trusts. So, as I've already said, it's all about enhancing the disabled beneficiary's quality of life. And
Okay, so sorry, I have two questions.
Yep.
The first question, I'm not sure, maybe Deborah, if she can clarify this a little, Deborah Carlson, can a testamentary trust be updated to ensure that the client gets Medicaid? So maybe Deborah, I think you can unmute yourself and assuming you're still on, and explain a little bit more what you are asking.
Hi, do you hear me?
Yes.
Hi, okay. Sometimes I have clients that are left money by relatives and it's not set up for Medicaid. So how does somebody go about showing Medicaid that they don't have access to, I guess, those resources? Because it was like left for them in an irrevocable trust, but or I don't even know if it's irrevocable, actually.
Well, Deborah, that's a big reason for why we have the first party supplemental needs trust. Because if you need Medicaid or on Medicaid and you receive a gift or a bequest, you're going to set up a first party supplemental needs trust or join a pooled trust. And that will avoid a problem with Medicaid.
And what if there are assets connected with this testamentary trust?
Well, that's what we're talking about. If the person who's receiving Medicaid benefits receives assets, receives those assets in their own name, that will likely compromise their Medicaid eligibility. So in order to avoid loss of eligibility and loss of Medicaid benefits, those assets should be put into a supplemental needs trust. And the recipient can do that. That's a first party supplemental needs trust.
And if they're over 65, what happens? Because you said there was an age requirement on that.
If they're over 65, then they use a pooled trust, pooled asset trust. So they can go to any of the same organizations that do pooled income.
Okay, thank you.
I'll also set up a pooled asset trust.
Great, thank you for clarifying that. Okay, and what kind of a trust would a testamentary trust be included in? So I think they wanted to know if you could put a testamentary trust into a trust that you create while you're living?
Well, yes. So let's call the other trust the main trust. So the main trust could be a revocable trust, or it could be an irrevocable trust. So the point is that in your main trust, you want to make a distribution to someone who you don't want them to receive their bequest simply as a lump sum. And you don't want that because they're disabled and it may compromise their benefits, or they're minors, or they're young adults, and you're uncomfortable about leaving a large sum of money to them at that age. So you want to defer the age when they receive their bequest, right? That's when you would use a testamentary trust. So in the main trust, you would say, I leave $100,000 to my niece, Jane. But since Jane is only 19 years old, I'm going to defer her receipt of that $100,000 until she's 25 or 30 or whatever age you want, because I'm more comfortable that by the time she reaches that age, she'll be mature enough to handle this amount of money properly. So that's a testamentary trust. We're deferring the distribution of the bequest. And we can also create a supplemental needs trust as a testamentary trust. In other words, I want to do something to benefit my disabled nephew. I'll do that in my will or my main trust. So I'm not going to leave him a sum of money because I know it will compromise the government benefits that he's receiving as a disabled person. So I will leave it in a testamentary supplemental needs trust. All right, so we could do that in a will or in our main trust. That would be your testamentary trust. Make sense?
Okay, yep, I think we're good. All right. It is 3 o'clock and we're supposed to finish by 3:15. So just to keep that in mind in case there are a few questions at the end.
Okay.
All right, so continue on.
So should I have a plan for long-term care? I would say emphatically yes, unless you're very wealthy. But bear in mind that the cost of needing long-term care is extremely high. It's very costly, and it's by definition long-term, and the risk of needing it is very high. You know, I think a lot of us would prefer not to think about this topic, but you know, statistically, about 7 out of 10 people over the age of 65 are going to need long-term care. So if you're one of those 7 out of 10, you're going to be spending a lot of money. You know, the cost of home care today, you know, you're going to spend in the New York City metropolitan area, you're going to spend $30 to $40 an hour. So take out your calculator and multiply that out and what that means in terms of what you're spending every day, every week, every month. It's a lot of money. I mean, we see clients all the time that are spending $5,000, $10,000 a month. And assisted living, nursing home doesn't get any better, it just gets worse. You know, we see clients spending $15,000 to $20,000 a month, sometimes even more when we get into the assisted livings and nursing homes. So it's a really serious financial risk. And I think that's why for so many people, it makes sense to think about the implications of this risk and let's do something about it. And one of the things we can do about it is integrate it with the estate plan, because the same trust that's going to protect my assets during my lifetime, it's also going to make me eligible for Medicaid and other benefits, is the same trust that's going to serve as my estate plan and avoid probate. So we can kind of put it all together into one piece of legal work, if you will. So of course, if you can afford to pay for long-term care and you're willing to do it, or if you've got good long-term care insurance, maybe you're fine right with that. So you have a plan. Your plan is, I've got enough money and I'm willing to spend it, and I've got good insurance, so I'm good. All right, if that's your case, that's a plan. If you can't afford it, and most people cannot, and you don't have insurance, and most people don't, let's think about what you can do. And that might well be your irrevocable asset protection trust, which again works for both purposes, as your long-term care plan and your estate plan. So if you have done what I've suggested here, and you've created an integrated plan, and you have a irrevocable asset protection trust, your assets are protected during your lifetime. They're protected against creditors, and they're protected in the sense that you can access programs like Medicaid for your long-term care. You have no probate proceeding. The assets can be distributed privately and efficiently, and your beneficiaries avoid capital gain tax. Again, I think all good news, and really don't have any bad news to report. So I think that's it.
Okay, and Matt asked a question, I think. Okay. So Matt asked a question: does using a revocable trust allow you to put off more difficult decisions that an irrevocable trust would help with? So I think what he's talking about is sometimes people expect, especially if they're younger, create a revocable trust at first, and then with the idea that they might be able to turn it into an irrevocable trust. Matt, is that what you were kind of getting at?
Yeah, something like that. I mean, the idea of turning your assets over to somebody else creates anxiety, no matter how much you might think you trust someone. But the idea of a revocable trust sounds great, right? I would still have control over assets. And it seems like maybe it's only a half step toward protecting assets, but I'm just wondering if people ever do it this way.
Matt, that's a very good question. And yes, people do it that way. And particularly the younger ones, I think, who are really not ready to deal with and contemplate those nursing homes and stuff like that. If you start out with a revocable trust, as we've already seen, that trust can be amended whenever you like, and more than once. So if you have a revocable trust, you've already done the hard work. You've thought about your estate plan. You've decided who your beneficiaries are going to be. You've decided how you want to allocate your assets among those beneficiaries. You've transferred your assets into the trust. So the trust already owns your house or your co-op. It already owns your securities investments. It already has a checking account, a savings account. It already owns other property that you may have decided to put in the trust, like artwork or a stamp collection or whatever it is that you own. So once you've done all of that, at any time in the future, you could decide, let's make this revocable trust irrevocable. Because once we do that, I'm giving up control, I'm naming a new trustee, but in return, I'm getting the asset protection and I'm getting the access to programs like Medicaid. And again, because the trust is revocable, it is amendable. So very simple to do an amendment that says this revocable trust is now irrevocable. And I resign as trustee and I appoint my son, my daughter, whoever it is I'm appointing, and name them as the new trustees. And now we have easily converted our revocable trust into an irrevocable trust. And from that day forward, we can profit from the benefits of an irrevocable trust.
Okay. There's somebody else on here called David Kuttner. So I think David might have forwarded his link to somebody. And that David Kuttner asked, at what age is it too late to begin saving for long-term care?
Wonder who that person is, though. At what point should you start saving for long-term care? Is that the question?
Yes. When you get your first paycheck.
Yeah, I think it's kind of a combination of age and health. You know, if you're healthy and you know, you could defer it longer than someone who's younger but has got health issues. So, you know, I think that for most of our clients that are thinking about, you know, these kinds of plans and involving irrevocable trusts, you know, they're in their 60s, 70s, 80s kind of thing. I think younger people are maybe more interested in the revocable trust and wills, of course. But you know, if you're at an age where you're married, getting married, you're having children, you know, you want to start thinking about an estate plan. And as you grow older, and you know, I think that your health is part of the equation. So you know, there's really no fit answer to this.
It was me. Sorry, I don't know why my name is on your name. The question was, at what point is it too late to begin? So like, let's say I'm 66, it doesn't pay anymore, right? It's too late, baby, right? I'm not, you were answering, well, when is it too young? When are you too young? Question said, when is it too late?
Oh, well, if you're 66, it's not at all too late, because we have plenty of clients at 76 or even 86 that are doing these kinds of trusts.
But it wouldn't cover, what would that cover in terms of long-term care? So from what I've been told, people say it doesn't, it's not, I guess for insurance. I mean, that's for the long-term care insurance. It's a different question, I guess. I'm not sure. I'm a little mixed up.
Well, if the question is, when is it too late to set up this kind of trust?
No, she's talking about long-term care insurance.
Maybe that's
that
That was, I think her question was about long-term care insurance.
Yeah, well, it's too late for that. You have to do that, you know, early.
Yeah.
That's to work out.
Well, even with long-term care insurance, you're in your 60s, it's not necessarily too late. It would depend on your health and how the underwriters will look at you in terms of your health. And it also will mean that the premium will be higher. The older you get, the more premium you're going to pay because
Yeah, no, I
the,
assumed that there wouldn't be a factor of insurance at this point. Let's say, I think that's what they're talking about.
I don't know who the they is you're referring to, but there's no kind of fixed cutoff date here for this. You know, it really depends on age and health. And
Yeah, I
as
think
far
that's-
as insurance goes, what makes sense for you? You know, for a lot of people that have bought long-term care insurance, we see this all the time. The policy didn't make any sense. You know, why did you even buy this policy? So it really
Okay.
just, there's no kind of fixed answer to this question.
Okay, so David, sorry, just before we have to go, there's one more question I think would be useful. Does a testamentary trust require a will and therefore it still requires probate?
Well, if the testamentary trust is contained in a will, then yes, it will require probate. If the testamentary trust is contained in another trust, which I've called the main trust, then there would be no probate.
Perfect. Okay, great. And then another just quick. Oh yes. So the person who asked, if you have a revocable trust and suddenly you need Medicaid, can you switch it over to become? Can you amend it to make it irrevocable and then be ready for Medicaid? And I think you might want to talk about the transfer, the issue of transfer. When the transfer is deemed to occur.
Well, the answer to that question really depends on what kind of care you need. If we're talking about community Medicaid, where you're looking for home care or assisted living, yes, it would work. If we're talking about nursing home, we have the 5-year look back. So the conversion of a revocable trust into an irrevocable trust is an act that Medicaid would view as a transfer of assets, subject to the nursing home look back, which is 5 years, and would cause a period of ineligibility. So
Perfect.
depending on the value of the assets in the revocable trust at the time the trust was converted to an irrevocable trust, that would dictate the period of ineligibility. But it does work and will work if we're looking for home care or assisted living care, because we're under community Medicaid where we don't have a look back.